Assalamualaikum warahmatullahi wabarakatuh, and hello Dr. Azni. My name is Muhammad Firdaus bin Daniel Tan, and we are from Group 1 of Law 554 then Law 2 Class K. In this video, my groupmate and I will be explaining about a land dispute between Ali and Murni, which involves the creation of a lien.
Hi Madam Azni, I am Fitria.
Hi, Assalamualaikum Doktor. My name is Nur Emily Adhana binti Intizam.
Hi Madam, I am the last member of the group. My name is Arisha Nabila. So, without further ado, let's get started.
Let's begin with the facts of the case. Sam is a registered proprietor of a piece of land in Muar. The land is subject to a restriction in interest that it cannot be transferred, leased or charged without consent from the state authority. Sam decided to sell the land to Murni for a sum of 300,000. Both Sam and Murni signed the sale and purchase agreement and Form 14A to perfect the transfer. Sam gave the title to the land to Murni for registration purpose after full payment of the purchase price. In order to pay the 10% deposit sum for the land, Murni applied for a loan of 30,000 ringgit from Ali. Murni deposited her title to Ali as a security for the loan, and thereafter Ali lodged a lien holder's caveat to protect his interests. The following month, Murni applied for a housing loan of 270,000 from Fulus Bank. As a security for the loan, Fulus Bank proposed that Murni charge the Sam land in its favor. Murni requested Ali to return the title for the purpose of registering the charge, which Ali did.
Question time! Murni has defaulted to pay the monthly installments to Ali for the past 3 months. Ali decided to apply for an order for sale, but Murni claimed that Ali lost his right to do so. Now, Ali seeks your advice whether he has lost his right over the land. Advise Ali.
Now, what is the issue of the present situation? The issue in this case is whether there is a valid lien created between Murni and Ali, and if yes, whether Ali has lost his right as a lien holder over the land. What is a lien holder's caveat?
So, what is lien? Lien is nowhere defined in the National Land Code. Nevertheless, in general, the party involved is a borrower and a lender. Lien is when a borrower borrows a sum of money or a loan from the lender. The idea of lien could also be derived from the wordings of Section 281 subsection 1 of the NLC that says it is the act of any proprietor or lessee depositing his title or duplicate lease to another person as security for a loan. So, what is the function of lien? Lien is a legal tool used to protect the interests of the creditors and other people who lended their money to the property owners. It creates an equitable interest in the land or lease which gives the holder of the interest the right to enter into lien holder's caveat.
Without further ado, let's jump into the elements of statutory lien. In order to create a lien, there are 4 elements that are needed to be fulfilled by both concerning parties. The first element to create a lien is there is an issue deposit of document title, or also known as IDT, by the registered proprietor. Now, according to Section 281 subsection 1 of the NLC, a lien can only be created by the registered proprietor of the land or the registered leaseholder. Meanwhile, Section 5 of the NLC defines the word proprietor as any person or body at the time being registered as the proprietor of any alienated land. In simple words, the right to grant a lien holder's caveat belongs to only the registered proprietor of the property. Right now, let's move on to the relevant cases. Prior to the year of 2008, the case of Hong Kong and Shanghai Banking Corp and Haji Salam bin Haji Daud The court upheld Section 281, subsection 1 of the NLC in very clear language, provided that only a proprietor of any alienated land may deposit his respective issue document of title or duplicate lease as the case may be. However, after the year of 2008, in Hong Yong Finance Sdn Bhd and Staghorn Sdn Bhd, it was held that Section 281 of the NLC do speak of the registered proprietor depositing his IDT as security for the loan, but it does not specify the borrower and neither does it restrict the loan to the registered proprietor. Hence, the loan may be a loan to a third party. The registered proprietor need not deposit the title himself. He may authorize or instruct the actual depositing to be done by someone else.
As duly mentioned in Section 281 subsection 1 of NLC, the second element of creating lien holder's caveat is the deposit of IDT. This process is done by the borrower or the registered proprietor handing over the IDT to the lender. So, what is the issue involving this element? The issue is, what is the status of the lien holder's caveat if the IDT is no longer in the possession of the lender? In the case of Sitang Barang Chetty and Ramanathan Chetty, the registered proprietor of the land created a lien by depositing his IDT in favor of the defendant, and the defendant lodged a caveat to protect his interests. Sometime later, the proprietor asked the defendant to give up the IDT, and he executed a charge over the same land in favor of the plaintiff. However, the registrar refused to register the charge because of the caveat. The plaintiff then applied to remove the caveat, which was then removed from the IDT. The court held that the defendant lost his right as a lien holder the moment he parted with the IDT, and therefore his caveat was removed from the IDT. The defendant is no longer a secured creditor and the charge took priority.
Now moving on to the third element. Well, the third element concerns the act of deposit of the issue document of title, or also known as IDT, to be made with the intention of creating a lien. The holder must show that the deposit was made as a security loan advanced by the holder to the proprietor, meaning the deposit of the IDT or duplicate lease or certified copy of title must have been made with the intention of creating a lien. Now let's look at the case of Nalamal and Karupanan. In this case, no one had informed the plaintiff about using her disputed land as security loan that had been taken by her own husband, and that the caveat has been lodged. It was held that the defendant had no right in law to make use of the IDT as a security for loan. The element of intention is not satisfied. The deposit of IDT as security was never authorized by the proprietor, hence, no lien has ever created. Such sections should be strictly construed and applied, or else the security of tenure of land would be seriously undermined.
After all those three elements have been perfected, Section 330 subsection 1 of the NLC provides that the lien holder or the depositee may apply for the entry of lien holder's caveat to the registrar. Section 330 subsection 2 further provides that the registration must be done under Form 19D along with the IDT or duplicate lease and the prescribed fee. So, what are the effects and the significance of the entry of lien holder's caveat? Once the caveat has been entered, the lender has officially reserved his interest over the land, and his caveat will give protection towards that interest. This caveat will also restrain all future dealings that have to do with the land. Not to forget, this entry of lien holder's caveat will also have the same effect as mentioned in Section 322 subsection 2 until subsection 5.
So, what are the possible avenues available to a lien holder in case the borrower defaults in payment? Well, there is a good news for those lien holders because they are entitled to invoke the statutory remedy to realize their security, which is by applying for an order for sale, an OFS, to sell the land in question. By virtue of Section 281 subsection 2 of the NLC, a lien holder is first required to obtain a judgment from the court for the amount due to him by the borrower before he is entitled to apply for an order for sale. only when the judgment is obtained, then only he can apply for an order for sale. This is further strengthened in the case of Alagappa-Chetty and Perianayaga, whereby Judicial Commissioner Ince mentioned that a lien holder's right to enforce the lien by way of judicial sale, which is an order for sale, is conditional, whereby it is only entitled to the lien holder upon proof that the borrower is indeed obligated to repay a debt to the lien holder. Last but not least, Section 281 subsection 3 of the NLC provides that any application for an order for sale must be made in accordance to Section 257 to Section 259 if it is in regards to registry title, and in accordance to Section 266 to Section 269 of the NLC if it concerns a land office title. As for the procedures to sell the land in this case, it is similar to that of charge.
Moving on to the application.
By pursuant to Section 281 subsection 1 of NLC, the right to create land only belongs to the registered proprietor of the land. In this present issue, it was stated that Sam is the registered proprietor and he decided to sell his land to Murni, where both of them signed the sale and purchase agreement together with the Form 14A to perfect their dealings for the transfer of the land. But the land is subject to a restriction in interest where the land cannot be transferred, charged or leased without the consent of state authority. In any circumstances, the land office may reject the Form 14A that was signed by Sam and Murni, as it was evident that there is no consent of state authority for the transfer of land, and registration for the title of land cannot be done by Murni. When Murni deposited the title to Ali as security of loan, the title might still in the name of Sam as registered proprietor. This is because there is a restriction in interest attached to the land requiring the consent of the state authority before it can be transferred. However, such consent has not yet been obtained. In this present issue, applying to the case of Hong Leong Finance Berhad against Tek Hon Berhad, Murni did not have the right to deposit the IDT to Ali until she became the registered proprietor of the land. Hence, the first element is not fulfilled, as Murni was not the registered proprietor of the land and she had no right to create a lien unless the land was transferred to her from Sam after obtaining the consent from state authority.
The second element that we will be looking at is the deposit of the IDT. In this case, it can be seen that Ali did receive the IDT from Murni as security for the 30,000 ringgit loan to her, as under Section 281 subsection 1 of the NLC. However, as explained before, since Murni is not the registered proprietor of the land, therefore she does not have the rights to deposit the IDT to Ali in order to create a valid lien. Besides, Ali parted with the IDT without the written request of Murni as required under Section 281 subsection 4 of the NLC. The case of Sitambaram Chetty and Ramanathan Chetty is very similar to this present case. What's so similar is that in both cases, the lien holder parted with the IDT to be returned to the proprietor for the proprietor to charge the said land to a particular bank. Likewise, Ali should not have parted with the IDT to be returned to Murni for her to charge the said land to Fulus Bank, because in Sitambaram Chetty, it was held that the lien holder lost his rights as a lien holder the moment he parted with the IDT and when the caveat was removed from the RDT. Not to mention, the very purpose of a lodgement of a caveat by Ali was to protect his interests and to prevent future dealings by Murni, which includes charge. Ironically, Ali still parted with the IDT to be returned to Murni for her to charge the land to Fulus Bank, which is the very thing that the lodgement of the caveat was meant to prevent.
So, what about the intention to create lien? Will this element be fulfilled? As for the element of intention to create lien, the intention to create a lien need not to be expressly documented, where it can be in oral or any written form. In this present case, it can clearly be seen that Murni had deposited a title to Ali as security for the loan that she applied for from Ali, which amount to 30,000 ringgit. Although the intention was not expressly documented in written form, the act of Murni deposit the title to Ali as security for her loan can be inferred as the intention to create a lien. Unfortunately, it doesn't end there. However, by applying to the case of Nalamal against Karupanan, no lien can be created because Sam, as a registered proprietor, did not authorize the lien. As a matter of fact, it also wouldn't be logical for Sam to authorize the lien since the purpose of Murni obtaining a loan is to pay for the land itself. It can be said that the lien cannot be created as the deposit of IDT must be made with the intention of registered proprietor, which should be strictly construed and applied. Therefore, the element of intention is not satisfied because deposit of IDT was never authorized by Sam since Murni was not the registered proprietor of the land unless the registration of the transfer of land is perfectly dealt with the consent of state authority.
The last element is in regards to the entry of a lien holder's caveat. In this present case, Ali is required to lodge a lien holder's caveat pursuant to Section 330, Subsection 1 of the NLC for it to become a statutory lien which is enforceable. And the form that needs to be used by Ali is Form 19D, as stated under Section 330, Subsection 2 of the NLC. From the facts of the case, we can see that Ali did lodge a lien holder's caveat immediately after receiving the IDT from Murni. So, what are the effects of a lodgement of a lien holder's caveat? A lien holder's caveat prevents any future dealings in relation to the land, such as charge, lease, or even a transfer of the said land. So, assuming that the lien created is a valid lien, and if Murni defaults in payment as a borrower, therefore Ali as the lien holder is entitled to invoke the remedies available under Section 281 Subsection 2 and Section 281 Subsection 3 of the NLC.
After a lengthy discussion with regards to the dispute between Murni and Ali, what can we conclude from this case? In conclusion, there is no valid lien created between Murni and Ali as the first, second and third element of statutory lien are not satisfied. This decision is made on three grounds. Firstly, Murni is not the registered proprietor, being that the transfer made between her and Sam was invalid. Secondly, Ali had parted with the IDT without any written request by Murni, which also defeats the purpose of lodging a caveat in preventing future dealings of the said land. Thirdly, there is no intention of creating a lien with Ali on the part of the rightful registered proprietor, Sam. So, on that account, there was no lien ever created between Ali and Murni in the first place, thus prohibiting him from applying an order for sale under Section 218 Subsection 2 of the NLC as he is not a lien holder of the land.
On that final note, that brings to the end of our presentation. Thank you for watching. Have a nice day and bye!